All right, Mr. Hicks, how much time would you like for rebuttal?
4 minutes, Your Honor.
4 minutes? Okay. You all set, Mr. Conover?
Yes, sir, thank you.
Okay, you can begin when you're ready, Mr. Hicks.
Okay, so I trust you judges. I appreciate this opportunity. I trust that you've read the filings with this case, and I want to put it very simply in layman's terms before getting into more substantive of it is, this ultimately, I'm asking for this case to be sent to the Clermont County Court and Judge Brock. I think it was improperly dismissed. And one of the things driving here, I remembered out of one of my briefs that really stuck with me, is this is about whether a township ultimately has to follow its own township zoning resolution and whether the citizens can rely on that. Then we get into all kind of things. We'll go down that pipe in terms of property values and so on and so forth. And let's pretend for a second, the actual township zoning resolution, one of the key points is it says, any use not specifically permitted is prohibited. And this related to putting a medical marijuana dispensary into our township proximate to my home.
Yeah, Mr. Hicks, if you wanna spend your time telling us about why you think the Board of Zoning Appeals decision or the Township Trustees decision violates the zoning code, you can, but the real issue in this case is whether you have standing, just assuming for the sake of argument that it does violate the zoning code. This case is about whether you have standing to vindicate that violation.
So let me correct, Your Honor, and I'm getting to the point and then I'll move on.
Okay, I'm sorry. Maybe I spoke too soon.
Let's just imagine that instead of saying what I just read, the actual township zoning resolution had said medical marijuana dispensaries are a prohibited use. That was exogenously in the township zoning resolution, and then the trustees approved a medical marijuana dispensary. What remedy at law, other than a 2506 appeal, would I have, which as we know 2506 has no standing defined in it, what remedy at law would I have as a citizen that there had been an overt violation? So I appreciate humoring me, Your Honor, on that point. But this comes down to what the zoning resolution said, what actually happened, and then what equates to standing in those conditions. What equates to standing in those conditions? So in my original 2506 filing, by the way, I think that in that case, kind of looking at the Willoughby case, that standing should confer to citizens just on the same basis that it did to the city in that case, where the town, in that case, the Board of Zoning, it was the Building and Zoning, whatever the name of it was.
Let me just say this. Section 682 of the zoning code says that if a use is not one that's specifically in the zoning code, then the zoning commissioner of the Board of Trustees can determine whether it's substantially similar to one of the B1 or M1 district uses. And then section 681 says that if there's a conflict between the PD regulations or an approved PD plan and other sections of the resolution, the PD regulations prevail. So doesn't that mean it prevails over the provision that a use not specifically permitted is prohibited if we're talking about a PD zone?
I don't believe so, Your Honor, but I think that would be something that would be good before the Common Pleas Court in Clermont County to determine about how this actually applies and what does that actually say.
Well, the point I'm trying to make, it's not as clear as you make it out that this action violated the zoning code.
So again, I think that would be a good case for why this should have been explored more is, in the dismissal, it was the traditional dismissal reasons you would have. I didn't live an adjacent lot. I couldn't prove my property value. When my thrust, although I made those arguments, the thrust of my argument was this was an overt violation of the zoning resolution, and what remedy otherwise does a citizen have, and do they not have the right to expect that the government follows its own zoning resolutions? Keeping in mind, Your Honor, that and you guys probably know this, but a township can change their own zoning resolution, but they need to have a hearing to do that. They need to do it in public, not kind of on the side without actually making those changes. So if you look at that actual, since you mentioned it, Your Honor, that zoning resolution, you can look at the specific things in there, and I want to point out that during the hearing, the actual zoning director could not specifically state what it fit in. And I had included in one of my briefs some excerpts, and there's a transcript of this, of where this actually fit. And one of the actual trustees was on the record of this does not fit in any of these uses. So again, I think that you've raised great points. I think that the point is back to what you asked, Your Honor, earlier, standing, do I have standing? So I point out in the brief, in the prior filings, the proximity of my house to this location, the possible impacts, but then this overriding, the initial thrust, was the overriding, I have an expectation that the government follows its own zoning resolutions in the township in which I live, and if they are going to change that they do it in a public fashion. I also want to point out, I'm sure you guys are aware, that I included an affidavit from the person whose kids play in the yard directly opposite what will be the entrance to a medical marijuana facility. I included an affidavit from a past trustee about, because as you know from reading the briefs, previously the interpretation of the trustees and administration up until these events was that it was a prohibited use and that it could not be done, including they had denied applications for medical marijuana dispensaries on the basis that the township zoning resolution prohibited medical marijuana dispensaries. There was a change that happened without any change to the township zoning resolution. So I included those. Neither of those people, the trustee lived on a whole different area of the township, but the person that lives close to me, whose kids will now be playing in a front yard facing a medical marijuana dispensary, that person was in no position to do a 2506 appeal. You know, I wasn't in a position to retain legal counsel for that purpose and the cost associated with that. So, but on the point of standing, which you brought up, this was dismissed on the point of that I didn't have standing. The arguments from Judge Brock in that dismissal were only around property values, things like that, the traditional measures. He never even addressed what I think is a key point from that Willoughby case is what happens when a board of, in this case it was the trustees that did the zoning decision, does something in conflict with the actual rules that they have established.
Well, what's the consequence? If the rules are violated, what is the damage? What's the injury?
I think the injury, Your Honor, I think it's a good question. The injury is if I as a citizen can no longer expect that the township zoning resolution that was put in place by a vote of the citizens is going to be honored and can just be willy-nilly disregarded. We can just do whatever we want.
What is the injury unique to you as a result of that?
I think, well, I want to use an example from First Amendment cases that I'm familiar with where, for example, me being blocked out of a meeting that I had a right to attend on the federal level would be an irreparable harm that came to me. I think that there's an irreparable harm to the citizens when they can no longer count on their government to actually adhere to the standards that the government published. So right now it's an even stranger situation.
But you don't speak for all those people.
I speak for myself
Right.
in the specific, and that's why I pointed out very clearly, I live proximate to this place. I live in the government has defined 9 corridors of Union Township. It's a very urbanish, suburbanish.
So your expectation has been breached. They've
Correct.
breached your expectation.
Correct.
But so the case law talks about a unique injury. So what is the unique injury to you because your expectation was breached?
I think if you look at, for example, the Willoughby case and what happened relating to the Willoughby case.
Willoughby's a little bit different because there's a municipal charter involved.
Okay. But I'm still saying that case, I think the important thing here is for you guys to consider, I'm pro se, so I apologize for
That's fine.
is what other remedy is there? And I think there is a unique injury. If I have an expectation when I buy a house, when I live in a community, that these certain things will not be here. And all of a sudden those things are there. I believe I'm suffering a unique injury, and when that's happening, specifically when it's happening in my area. Since this has happened, because there was public outcry over it, there have been, I think, 3 or 4 120-day moratoriums on any more pot shops. So this has created an even more bizarre situation where our area has basically a rump pot shop that was approved in this manner where they still haven't changed the zoning resolution. Now there can't be any more. So I think I'm uniquely harmed also when my corridor, the Mount Carmel Tabasco mixed-use corridor, now has something in it that's not allowed in other corridors because it's been suspended. Again, it's been, I think, 3 or 4 times on 120-day type extensions of a moratorium on this. I think that in itself reflects that there's an issue here. There's an issue here that they went off the script. And I think that I suffer a unique harm when in my particular area, proximate to my house, this is happening. I have to drive by. There's a couple ways I can drive out of my house.
You know, though, unique harm has been defined as something separate and apart from what is sustained by the community at large. How is that harm that you've suffered different from what's sustained by the community at large?
Your Honor, I think I went through that some in terms of now only my corridor. There's actually 2 corridors that have these in them now. There's been a moratorium, so that got snuck in. But I want to come back on this unique harm thing because a little bit here is 2506 has nothing about unique harm, about what defines standing. So the standing is all defined through case law. And I think in this case, we're looking at, this isn't your typical next door to me, they're doing this, and it's making the traffic crazy, it's doing this, it's doing that. This is at a kind of a different level that has to do with the body did something in conflict with its actual own rules. And so that the unique harm argument, I think is very important. Obviously, you guys are going to consider it, but I think you also have to consider what other recourse would a citizen have, and how can we expect, basically, I think on a bigger scale, what makes it difficult for you in this decision is this could effectively say township zoning resolutions are meaningless. Because if they don't have to adhere to their township zoning resolution and they can just do whatever they want, why bother to have them? So thank you.
Okay.
I do want to clarify. When you talked about Willoughby Hills, you acknowledged Judge Piper's point about how that case was a little different because there was a charter that said that the city could appeal the township's zoning decision. Just to clarify, what was why is Willoughby applicable here?
So that was not a city appealing a township case.
I'm sorry.
It was a city appealing its own, whatever the right name was. The equivalent would be like the Board of Zoning Appeals on a township level. They were appealing because the councilmen of the city were the decision made by the Board of Zoning Appeals.
And I understand it. I just used the wrong term. But
So it was the case that in that case, what I think is so important about it is it states that there's an overall interest, obviously on the part of government, that its subordinate functions follow the standards that have been put in place. So therefore, a 2506 appeal was appropriate. And I'm pointing out, as citizen, I'm not just saying they're putting a gas station next to my house and it's going to create too much traffic. I'm saying they're doing something that is in direct conflict with not only, and I follow this stuff very closely, not only with the township zoning resolution, but because I follow it so closely, with past things. So I came to rely not just on the township zoning resolution, but that they had previously denied applications for medical marijuana facilities on the basis that it was not permitted by the township zoning resolution. So all of a sudden they changed that without actually changing the township zoning resolution. And then I'm at a loss if this case can't even be heard at the common pleas level or a dismissal based on those actual points. I'm at a loss of what's the recourse for citizens and what's the value or meaning of township zoning resolution.
Usually when there's not a recourse, a person files a writ.
I'm sorry?
Usually when there's no remedy at law, a person files a writ.
Okay,
What made you decide not to file a writ?
because I thought that a 2506 appeal versus, for example, a writ of mandamus was more appropriate to this particular fact set. And I think a 2506 appeal with the Willoughby case, there's a good mental process. You guys can determine the legal mentality of that this has to be something that can be appealable. Because as we know, 2506 doesn't actually, most of what gives standing is based on case law, not based on that 2506 particularly confers standing based on any criteria.
Okay, other questions?
Thank you.
All right, thank you, Mr. Hicks. Mr. Conover?
Thank you, Your Honor, and may it please the court, Brody Conover on behalf of the Union Township Board of Township Trustees. I want to just make a couple of points here in response to Mr. Hicks and the questions that you all presented to him, but really primarily redirect this case, that this is a case on standing. As Judge Powell pointed out, this isn't really getting to the merits of the underlying case, whether the zoning resolution, what sections apply, and Judge Brock, I think, acutely recognized that in his decision. In the last paragraph of that decision specifically noted that he wasn't passing judgment on the merits of the case, but really this is a case of standing. And in order to it's Mr. Hicks's burden to prove that he has standing to continue with this case. And as this court has said, Alisi, I think, is the most kind of on point, relevant case from this district, but the Supreme Court numerous times, at least since the 80s and early 90s, has recognized that there are two ways that a private property, third-party property owner can prove standing. And to do that, they must have, one, actively participated in the hearing. There's not a dispute that Mr. Hicks testified at the underlying administrative hearing in front of the Board of Trustees. But the second point is that he must demonstrate that he is directly affected and uniquely harmed by the decision. And Judge Piper and Judge Powell both asked questions related to that, kind of trying to ask Mr. Hicks, how was he uniquely harmed? And again, I think his answer today is different than what we heard first at the administrative hearing, right? So he got up and asked a question of the applicant, presented a question to the applicant, and then again asked one of the board. And to paraphrase it, it's in the record of the transcript that we filed. It's docket number 10. But it essentially says on page 23 that how can we as a community trust the applicant to be a good community partner if you're going to locate this medical marijuana dispensary among single-family homes and near a school, St. Veronica School, private schools down that way. It's about 1,500 feet away from the medical marijuana dispensary, which the General Assembly has said that no, none of these can be done within 500 feet. So it's even outside that. No one from the school testified at the hearing or anything like that. So even at the hearing, which is what the record is composed of in this case, Mr. Hicks didn't talk about the zoning resolution. He didn't talk about a devaluation of his home. He didn't talk about an increase in traffic. He didn't talk about an increase in crime. It really wasn't until his memorandum in opposition to the township's motion to dismiss at the trial court level where he first raised these issues, which I think is probably means it's not a part of the record to consider as it relates to his standing to file the administrative appeal. But even so, all he did was present an affidavit from the guy that lives across the street that said, oh yeah, Mr. Hicks is going to be harmed. All he did was present an affidavit from a former trustee who was in attendance also at the hearing and said, hey, we may have handled these very differently in the past. But again, I don't think any of those, the affidavit from Mr. Haas or the affidavit from Mr. McGraw, show or prove that Mr. Hicks is going to be uniquely harmed in this case. In the Alisi case, again, this is the 2014 Flying J case. I know it because I lived close, I grew up close to that. But the long and short of it was they were building the Flying J out there at 123 and 71. A number of residents objected. I think the 78 residents were part of an appeal from the Rural Zoning Board decision to the Warren County Common Pleas Court. I think only 58 made it to the 12th district, but in that case, standing was never raised at the trial court level, but on appeal, this court sua sponte raised standing and ultimately said, one, at paragraph 18, that the burden rests with the resident to prove that he has standing. At paragraph 19, goes through the Supreme Court's history of the two-pronged approach of having actively participated and having been directly affected and or uniquely harmed by the decision. And then at paragraphs 21 and 23, ultimately decided the residents here at the hearing, the underlying administrative hearing, didn't say anything that wasn't some concern of the community. Hey, it's gonna be, we don't want this. I remember it was prostitution. It was, we don't want an overnight truck stop. There's gonna be increasing crime and traffic. And hey, we don't really think this fits the rural nature of Turtle Creek Township out there on the other side of 71. And the court sua sponte said this is not enough to satisfy the directly affected and uniquely harmed standard that the Supreme Court has outlined. And so they dismissed the residents from that case. The parties also kind of cross-appealed, and they ultimately decided in favor of pilot on that as it related to one of the conditions imposed by the Rural Board of Zoning Appeals. But that case, I think, really illustrates the issue here is that Mr. Hicks has never articulated with support how he is going to be uniquely harmed, other than to say that, well, the zoning resolution, I'm entitled to have that enforced. And there are ways for him to do that. I think of RC 51924, that is in the township zoning. It enables someone that, again, it has to be an adjacent property owner, which is similar to, I think, the case law here, but it allows someone to essentially bring a private cause of action for a zoning violation. I think there's a mandamus action, there's deck actions. There are, I think, ways that could have been pursued here that are more appropriate, where he might have standing. I still think there has to be an articulable harm to him in doing so, and I don't think there's been a court that has said, a general violation of the zoning resolution satisfies that. I think the Middletown v. Moore case, I know Jens Lanzinger in her concurrence specifically noted that. It was a slightly different context, but still a zoning law. So I just don't think that there's any support whatsoever to articulate, or for Mr. Hicks to be able to articulate that he has standing and to prove to satisfy his burden that he has standing. I know that I have time left, but I think I've both briefed and talked about it enough today, so unless there's any questions, I'm happy to sit down and ask for affirmance of the trial court's decision.
No.
Piper?
Good, thank you.
Thank you, Mr. Conover.
Thank you, Your Honor.
Mr. Hicks?
Don't you normally ask him?
Want to know how much time, thanks for keeping me on task. How much time, Mr. Richardson?
3 minutes, Your Honor.
Okay, 3 minutes.
Thank you. So just to clear up a few things that Mr. Conover mentioned, I go to township trustee meetings, I only happened to be there by luck when this happened, because there was no public announcement that this was even going to happen. Even in the agenda for the meeting, there was nothing that implied that it dealt with medical marijuana. So I love the notion of quoting what I said in the hearing without any context of that I was one of the last speakers and a bunch of other people talked before me, et cetera, et cetera. So we keep coming back to these measures, obviously have directly affected unique harm, and that maybe then we get to, I should have used a different approach. I don't think there's anything in 2506 that precludes, it's an appeal of administrative decision for something like what I'm talking about. If we just apply cases that are kind of unrelated, that are precedents that I understand and appreciate, that have to do with more parochial, local, we don't want a truck stop, we don't want this, we don't want that, then I'm going to lose here. But what I'm pointing up is that I think in this case, using the Willoughby Hills case, where they talked about directly affected and the lack of need to be directly affected in the case of the municipality, that my point is very clear, and that I tried to buttress it. My point is very clear in that this was a violation of the township zoning resolution. I buttress that by bringing up that I think I am uniquely harmed, and I even did so today, by this rump stub pot shop being in my area that's not in any other area of the township, because they put a moratorium on these after this all happened. So again, I guess you could make the argument, well, I should have done a different approach than the statutory approach the legislature put in place. But I'd ask you, do you think that the legislative intent of 2506 was that this wasn't the kind of thing that could be appealed? I understand that there's case law relating to more parochial things, like the location, if somebody wants to put a gas station next to my house, I feel my property value is going to be affected, et cetera, et cetera. There's those traditional measures. I think I can apply those, and I think I am directly affected. I think I do have unique harm in that I have to drive by this place every day, and other people in our township don't, because there isn't one by them because of this rump situation. But all that being said, I think ultimately the notion that, for example, I can't do a 2506 appeal because I should have done something different, I don't think is I would appreciate it. That's not the way this court found. And I think what I'm asking is something very simple. This should go back to the trial court in Clermont County. If Judge Brock wants to do something involving actually dealing with that issue of a violation of the township zoning resolution, he never brought up any of these arguments. Judge Brock didn't, that I should have done it a different way, that I used the improper mechanism. He just stuck to the traditional, you didn't show your property values were affected. So I appreciate the time. Any questions?
Thank you, Mr. Hicks. We'll take the matter under advisement, gentlemen, and issue a written opinion.